Hello, Mr. and Ms. Velarde. This is our attorney.
Good day. Good day. Good day to you.
Let's have a seat and proceed with the sales.
Okay.
Our attorney will be presenting you the deeds of sale with assumption authority.
My client, Mr. David Raimundo, acknowledges your payment of 800,000 to his complete satisfaction and hereby sells this parcel of land together with the house and other improvements thereon. That this parcel of land, together with the house and other improvements thereon, are mortgaged to BPI to secure the payment of loan of 1,800,000 pesos. As part of the consideration of this sale, you, Mrs. Avelina Velarde, hereby assume to pay the mortgage obligations in the name of Mr. David Raimundo, including interests and other payment levied by the bank as if the same were originally signed and executed by you. Furthermore, it is agreed and understood by the parties herein that the capital gains tax and documentary stamps on the sale shall be for the account of Mr. Raimundo, whereas the registration fees and transfer tax thereon shall be on your account. Do you accept this?
Yes, I do accept.
As part of this document, here is an undertaking that you must sign that reads that you, Mrs. Velarde, with the consent of your husband, Mariano Z. Velarde, do hereby bind and obligate yourself, your heirs, successors, and assigns to strictly and faithfully comply with the following conditions. 1. Until such time that your assumption of the mortgage obligations is approved by BPI, you shall continue to pay the said loan in accordance with the terms and conditions of the deed of real estate mortgage in the name of Mr. David A. Raimundo, the original mortgage. In the event you violate any of the terms and conditions of the said deed of real estate mortgage, you hereby agree that your down payment of 800,000 pesos plus all payments made with BPI shall be forfeited in favor of Mr. David Raimundo, as and by way of liquidated damages without necessity of notice or any judicial declarations to that effect, and Mr. David A. Raimundo shall resume total and complete ownership and possession of the property sold by way of deed of sale with assumption of mortgage, and the same shall be deemed automatically cancelled and be of no further force or effect, in the same manner as it is, same had never been executed or entered into. Lastly, that you are executing the undertaking for purposes of binding yourself, your heirs, successors, and assigns to strictly and faithfully comply with the terms and conditions of the mortgage obligations with BPI and the covenants, stipulations, and provisions of this undertaking. Do you accept?
Yes, sir.
Mr. Velarde?
Yes,
Excuse me. You should sign the contract here. Signing both of you. That's what doing business with you.
Thank you. Thank you, Mr. and Mrs. Velarde.
Hi, good morning, ma'am. Are you Mrs. Avelina Velarde?
Yeah, yes I am.
Oh, there's a letter for you from BPI.
Oh, thank you.
Oh, just please sign here na lang, ma'am. Here's a pin.
Okay.
Okay, thank you very much, ma'am. Have a good day.
Thank you.
What is that?
A letter from BPI.
Oh,
Now it must be the letter of our assumption of mortgage. Come on, open it, read it.
Okay. Dear Mrs. Adelina Velarde, we regret to inform you that your request for the assumption of mortgage obligations of Mr. David Raimundo amounting to 1,800,000 pesos Philippine currency with the Bank of the Philippine Islands has been denied. Caesar to your BPI management.
Our assumption of mortgage from the has been denied.
Hello, attorney. This is David Raimundo.
Hello, sir. Is there a problem?
Yes, it's about the Velardes. It has been almost 2 months since they last paid.
And when was that, sir?
Their payment was November 19 of last year. I found that out from BPI when they sent me a letter for non-payment of the mortgage for almost 2 months now. I also found out from the BPI when I called them about that the Velarde's request for assumption of mortgage was denied.
Oh, I see, sir. Well, that's a problem. With their non-payment to the mortgage bank, it will constitute non-performance of their obligation.
What will I do?
Well, we'll write them a letter informing them about the non-performance of their obligation.
Okay, thank you.
I am willing to pay the balance in cash not later than January 21 as long as they deliver the actual possession of the property to me not later than January 15. Second is that release of title and mortgage from BPI and make the title available and free of liens and encumbrances. And lastly, execute an absolute deed of sale in my favor, free from any lienses and encumbrances, not later than January 21, 1987.
Okay, ma'am. I'm going to write a letter to them containing all of what you said.
Okay.
Sir, the Velarde sent us a letter giving conditions to pay the full balance in cash.
So, what should we do?
We should cancel the intended sale because they failed to comply with the terms and conditions of the contract. We'll send them a notarial notice about the cancellation of the intended sale.
Okay.
The court hereby dismisses the complaint of petitioners Mariana Z. Velarde and Adelina D. Velarde against private respondents David A. Raimundo and George Raimundo of specific performance, nullity of cancellation, and writ of possession and damages. The court hereby grants the petitioners Mariana Z. Velarde and Adelina D. Velarde motion for reconsideration and directs the parties to proceed with sale. Petitioners Mariana Z. Velarde and Adelina D. Velarde must pay the balance of 1.8 million pesos to private respondents David A. Raimundo and George Raimundo, who in turn are ordered to execute a deed of absolute sale and to surrender possession of the disputed properties to petitioners.
Whereas the order dated May 15, 1991 is hereby annulled and set aside, and the decision dated November 14, 1990, dismissing the complaint, is reinstated.
The bonds posted by plaintiffs
Mariana Z. Velarde and Avelina D. Velarde, and defendants David A. Raimundo and George Raimundo are hereby released.
Wherefore, the sale decision is hereby affirmed with the modification that private respondents are ordered to return the petitioners the amount of 874,150,000, which the latter paid as a consequence of the rescinded contract, with legal interest thereon from January 8, 1987, that the date of decision, no pronouncement as to cause, so ordered.